Can we receive the report from the Honorable Mpaka?
Thank you, Right Honorable Speaker. I beg to lay the report of the Sectional Committee on the state of the affairs at the National Social Security Fund. I beg to lay the minutes and the supporting documents.
Please lay.
Right Honorable Speaker and Honorable Members, a report on the Select Committee on the state of affairs at the NSSF Fund. Introduction. On Wednesday, 25th January 2023, during the communication from the Chair, the Right Honorable Speaker of Parliament constituted a Select Committee to investigate the state of affairs at the NSSF. The Select Committee was given specific terms of reference and was required to exercise its mandate under Rule 190 of the Rules of Procedure of Parliament and the Republic of Uganda, and to report back to the House within 1 month. The Select Committee has therefore carried out a thorough investigation into this matter and has agreed to report the following. Honorable Members, the background is on page 5. The rationale is on page 6. Allow me to go straight to the terms of reference for the interest of time. In executing its mandate, the committee was guided by the following terms of reference: to examine the corporate governance structures at the NSSF Fund; 2, to examine the circumstances surrounding the appointment of the fund's managing director; 3, to evaluate the status and safety of the savers' money in the fund; 4, to examine the extent of stakeholder engagement in the decision-making at the fund; and lastly, to inquire into any other matter incidental thereto. On page 8, there's the methodology. On page 9, we made reference to relevant laws, regulations, and instruments. They're indicated on page 9. And again on page 9, we analyzed documents submitted by the witnesses. On page 11, desk research was also carried out. Allow me to go straight to 4.0. Comparison of the National Social Security Fund of Uganda and similar funds in the region. That is on page 11 and page 13. The governance structures at the fund before and after the National Social Security Fund Act, Amendment Act 2022. It should be noted that, that following the gazetting of the NSSF Fund Amendment Act 2022, that largely transferred the supervision of the NSSF from the Ministry of Finance to the Ministry of Gender on 7th January 2022, Section 29.
Why are you disorganizing somebody who is flowing?
Right Honourable Speaker, I thank you for giving me this opportunity. Right Honourable Speaker, we are handling a very important matter, which is the National Social Security Fund report. And the Right Honourable Speaker, the Minister in charge of this docket is totally absent in this House. And the order paper, this item has been on the order paper, not just this afternoon, but has been there. And the Right Honourable Speaker, I was aware that this item is coming, and all the members and even the Minister. So the procedural matter I am raising, if it is intention, because there are 4 ministers. No, I am very informed, because NSF falls both in finance and in gender. And the minister in charge, the gender minister, is totally absent here. Oh, there is one. Right Honourable Speaker, the procedural matter I'm raising, would it be procedure right for the minister in charge of the docket to be summoned, to be present in the House as we handle this matter now?
Can we hear from the acting Government Chief Whip? We are discussing a very serious matter on the NSSF. The minister responsible is not here. What information do you have for us? But we have one minister of gender. We have Honorable Samuel.
Right Honourable Speaker, I'm aware that Honorable Samo is a minister in the gender subsector. I want to request, and I also have a Minister of Finance here. I have the Attorney General here. So my guidance would be that Honorable Samo, as of now, handles the docket. As you give me, Right Honorable Speaker, I beg for your indulgence that maybe you permit me to call the Minister of Gender, then I get back to you in 1 minute. Let me get her on phone.
Honorable members, we have a lot of work in the order paper. We have a minister here, Honorable Asamo. We are not going to start postponing our work because the ministers are not here. We have a Minister of Finance. We have a very able Attorney General here. And we are looking at gender. Please go ahead.
Thank you, Right Honorable Speaker. It should be noted that following the gazetting of the NSSF Fund Amendment Act 2022 that largely transferred the supervision of the NSSF from the Ministry of Finance to Ministry of Gender on 7th January 2022, Section 29 of the NSSF Act grants the power to the Ministry of Gender to approve or disapprove with amendments the NSSF budget with reference to Section 2 of the definition part. The Minister responsible for Social Security is the supervisor to the fund. Section 30, as amended, introduced the role of the Minister of Finance, Planning and Economic Development with the authority to approve or disapprove investment-related aspects in the NSSF budget. This is how the dual supervision was created. Whereas the old NSSF Act did not specify on the individual representation to the board and gave the Minister of Finance discretion in appointment, Section 3 of the NSSF Act as amended introduced a tripartite stakeholder board appointed by the Minister, which comprises of the chairperson, the permanent secretary of the Ministry responsible for finance, the permanent secretary of the Ministry responsible for labor, 4 representatives of employees nominated by the federations of labor unions, 2 representatives of employers nominated by the Federation of Uganda Employers, and the managing director, who shall be an ex-officio member without the right to vote. 5.1 Supervision structure of NSF before 2022 and its impact on governance. The committee was informed by the former managing director NSSF about how regulatory and oversight framework of NSF has evolved since 1985, when it was established as a body corporate, in light of governance challenges, notably in 2004, when the NSF was transferred from the Ministry of Gender to the Ministry of Finance, in 2011, when the Uganda Retirement Benefits Regulatory Authority was created. It was noted by the committee that due to a breakdown in the governance structure of the NSF, corruption scandals leading to the arrest, prosecution of the chairman of the NSF board, managing director, a contractor, the minister responsible for labor, who jumped bail and fled into exile in the early 2000s, His Excellency the President, in a letter dated 6 September 2004, to the then Prime Minister of Uganda, the late Right Honorable Apollo Nsibambi, directed the immediate transfer of the NSF from the Ministry of Gender to the Ministry of Finance. In his letter, he highlighted, I have decided with immediate effect to transfer the NSSF fund from the Ministry of Gender, Labor and Social Development to the Ministry of Finance, Planning and Economic Development. The money in NSSF is too much to be handled by a non-specialized ministry. The Ministry of Finance is to review NSSF decisions and ensure that they are sound business-wise and are free of corruption. Honorable members, 5.2, challenges to the supervision structure of NSF following the National Social Security Fund Amendment Act 2022 and its impact on governance. The committee noted that on 7th January 2022, the NSSF Fund Amendment Act came into force. The amendments to the Act provided for the dual political and technical supervision by the Ministry of Gender, Labor and Social Development, and the Ministry of Finance, Planning and Economic Development, with the latter responsible for investment as specified in Section 30, 31, 34, 35, and 36 of the Principal Act, while the former is responsible for oversight and administration of the NSF respectively. However, the separation of the roles of the ministers presupposed that the provision of NSF Act were exclusive A case in point is separation of the approval of the annual budget estimates by the Minister of Gender from the approval of investments and declaration of annual interest by the Minister of Finance. And yet these two are closely intertwined activities. The committee observed that the guidance of His Excellency the President in a letter dated 4th October 2019 to the Right Honorable Rebecca Kadaga, the Speaker of the 10th Parliament of Uganda, confirmed his decision to have the fund supervised by the Ministry of Finance and Ministry of Gender. The letter tabled by Honorable Matia Kasaija, the Minister of Finance, Planning and Economic Development, from His Excellency the President reads, Right Honorable Speaker, as you are aware, in September 2004, I directed the transfer of the NSSF from the Ministry of Gender, Labour and Social Development to the Ministry of Finance, Planning and Economic Development. The main reason for this is that the Ministry of Finance, Planning and Economic Development is a specialized government agency to oversee the management of large funds. The ministry also has the capacity to review the NSF decisions and ensure that they are sound business-wise and free of corruption. I reaffirm my earlier decision on this matter. I do not agree with the proposal of NSSF Amendment Act, NSF Amendment Bill 2019 to split the oversight mandate of the NSSF under two government agencies. The proposed arrangement would cause delays in the decision-making and create loopholes for corruption. I am therefore requesting that Parliament streamlines the oversight role of the NSF under the Ministry of Finance, Planning and Economic Development in the ongoing amendments to the NSSF Act. The Ministry of Labour, Gender and Social Development is represented on the board of NSSF. Multiple apex authorities are dangerous for accountability. If things go wrong, whom shall we blame? The committee noted that dual oversight mandate has indeed caused delays in the decision-making in NSSF, created loopholes for corruption, and has blurred lines of responsibility and accountability from the two ministries. The committee mentions include A, in the budget approval letter dated 16th June 2022, the annual budget estimates financial year 2022-2023 were approved by the Ministry of Gender, who deferred approval of real estate investment budget estimates and set conditions without consulting the Minister of Finance of Uganda. On page 18, observations. The committee observed that in less than 1 year of transferring the NSSF back to the Ministry of Gender, allegations of corruption, influence peddling, and delayed decision-making scandals are back to haunt the savers. This is impacting negatively on the fund's reputation. Terms of reference, honorable members and Right Honorable Speaker. In handling the assignment, the committee examined the terms of reference here under reports. 6.1, to examine the circumstances surrounding the appointment of the fund's managing director and deputy managing director. The appointment of the managing director and deputy managing director is provided for under sections 39 and 40 of the NSF Act Cap 222 as amended by Act number 1 of 2022. Prior to the amendment of the NSF Act Cap 222, the appointment and tenure of the office of the managing director and the deputy managing director were a sole discretion left to the minister responsible to the fund. 2. The NSF Amendment Act 2022 amended sections 39 and 40 of the NSF Act Cap 222 and created the appointment of the managing director and the deputy managing director by the minister upon the recommendation of the board of directors for a period of 5 years and are eligible for reappointment for one more term upon satisfactory performance. 3. On 1st July 2022, Mr. Chimbowa, the chairman of the board of directors of NSF, notified the Ministry of Labour, Honorable Betty Amongi Ongom, of the board's decision on the recommendation to the reappointment of the managing director and deputy managing director of NSSF. The board highlighted, among others, exceptional stewardship of the fund, widely acknowledged positive transformation of the fund, and that the two officers tick all the performance boxes on technology, human capital, innovation, customer obsession, and sustainability. The board therefore recommend for their reappointment of the two officers for a 3-year contract effective 1st December 2022 and 30th October 2022 for Mr. Richard Byarugaba and Mr. Patrick Ayota respectively. On 18th July 2022, Mr. Patrick Ayota, the Deputy Managing Director, notified Honorable Betty Amongi, the Minister of Gender, of his retirement, having attained the mandatory retirement age of 60 years in accordance with the NSF Human Resource Policy Manual under section 23(3)(1). On 20th July 2022, upon receipt of the notification of the retirement from Mr. Ayota dated 18th July 2022, the minister reappointed Mr. Ayota as the Deputy Managing Director of the fund for a 1-year contract. The said reappointment was based on the recommendation of the board dated 1st July 2022. However, on the 22nd July 2022, Honorable Betty Amongi directed Mr. Richard Byarugaba to retire as MD of the fund, having attained the mandatory retirement age of 60 years in accordance with NSF Human Resource Policy, Section 23(3)(1), before he could be considered for reappointment. Furthermore, the minister in the same letter directed Mr. Richard Byarugaba to cease forthwith exercising the mandate and functions of the Office of the Managing Director, NSSF, and designated Mr. Patrick Ayota, the Deputy Managing Director, as the acting Managing Director until Mr. Richard Byarugaba retires, in accordance with the NSF Human Resource Money. On 22nd July 2022, Mr. Richard Byarugaba notified the Honorable Minister of his retirement from office of the Managing Director of NSF and also expressed his desire to be reappointed as the Managing Director of the fund in accordance with NSF Human Resource Policy and Procedures Manual for the retention of mission critical talent who have reached the fund's retirement age. The Attorney General, upon receipt of the copy of the letter dated 27th July 2022 from the Honorable Minister, stopping Mr. Richard Byarugaba from exercising the mandate and functions of the Office of the Managing Director of NSF, having clocked the retirement age of 60 years, rendered a legal opinion contained in his letter dated 22nd July 2022 to the effect that the 5-year term of the MD was still valid and would continue in force until its lapse on 1st December 2022. In other words, the purported forceful retirement of the MD was unlawful and contrary to sections 39(1) of the NSSF Act and the instrument of appointment. Subsequently, the minister received the letter of recommendation for the reappointment of Mr. Richard Byarugaba from His Excellency the President in a letter dated 6th August 2022, in which the President noted the need for quiet consultations before the appointments are concluded. His Excellency the President further noted that the growth of the fund from 1.7 trillion in 2010 to 17.2 trillion as at end June 2022, under the leadership of the MD and Deputy MD, NSF, the President directed the issue of the appointment was to be discussed before Cabinet on 20th August 2022. The Minister, however, on 30th November 2022 issued another instrument of reappointment of Mr. Patrick Ayota as Deputy MD of the fund for a period of 5 years with immediate effect. On 7th December 2022, well after the Cabinet meeting on 20th August 2022, the Honorable Prime Minister, in her letter addressed to the Honorable Minister of Gender, recommended for the reappointment of Mr. Patrick Byarugaba as Mr. Richard Byarugaba, as the MD of the fund. The Right Honorable Prime Minister noted that His Excellency the President had tasked her with a mandate to conclude the matter in a State House meeting held on 6th December 2022. Furthermore, the Right Honorable Prime Minister notified the Minister for Labour that comprehensive consultations with key stakeholders on the matter had taken place, and therefore directed Honorable Betty Ongom to reappoint Mr. Richard Byarugaba as the Managing Director NSSF, as recommended by the NSSF Board, to avoid managerial gaps which could put the Savers Fund at risk. The Right Honorable Prime Minister further advised that the allegations submitted by the Honorable Minister responsible for Labour against the MD have been referred to the Auditor General for investigations. On 15th December 2022, Honorable Betty Ongom responded to the letter of recommendation dated 7th December 2022, authored by the Right Honorable Prime Minister, declining the reappointment of Mr. Richard Byarugaba, citing the one-on-one confidential meeting on 9th December 2022, and requested to first brief His Excellency before commencing investigations. Honorable members, defer of reappointment of the Managing Director NSSF. On 7th December 2022, the Honorable Minister for Labour deferred the reappointment of the MD, citing a wide range of issues which needed to be investigated before Mr. Richard thereto tabulated as hereunder. Financial impropriety, pension towers. This is in regard to the variations. In the second column, those are responses of Mr. Richard Byarugaba. In the third, those are responses by the committee. Mr. Richard Byarugaba, in a nutshell, said the variations were within the PPD allowance of 25%, because the total of all the three variations were 23.91%. When the committee asked the Honorable Minister for evidence, the Minister provided no evidence to support the allegations. Honorable members, let me move straight to page 25. The existing crack, because all those are similar, they are in regards to the variations.
Thank you, Madam Speaker. Madam Speaker, unlike other reports which were loaded on the iPad much earlier for members to follow, this report was loaded at 3:40 p.m., about 15 minutes before he started presenting. Is he proceeded right now to start skipping very important information, and yet members have just accessed this report and are aware that thereafter we will be required to debate in a manner? I therefore implore you, Madam Speaker, that the chairman reads word for word. In the absence of doing that, Madam Speaker, then you will allow members adequate time to go and prepare and come and debate this report.
Honorable members, are you not following? The chairman is doing a very good job. Chairman, go ahead.
Thank you, Right Honorable Speaker. On page 25, the existence of a crack in the building, this is Pension Towers. Mr. Richard Byarugaba stated that the supervising consultant asserts there is no crack. The minister provided no evidence to the committee to support the allegations. On page 27, misinterpretation by the managing director of the budget for strategic land purchase. The real estate budget for 2022-2023 of 943 billion had an item of 400 billion for strategic land purchase for Nachigalala, yet the minister had obtained a valuation of 246 billion for the same land. Mr. Richard Byarugaba stated that due to the numerous claims relating
What
to
did you say? No, first repeat what you have just said.
Misinterpretation. I'm on page 27.
No, I just want you to repeat what you've just said.
Due to the numerous claims relating to the ownership of the land, which required lengthy due diligence and approval process, there is no money that was ever approved for the purchase of the Nachigalala land. That is a response by Mr. Richard Byarugaba. The minister provided evidence and the committee will report below. Corruption in the purchase of the MTN shares. Mr. Richard Byarugaba stated that the IPOs are regulated offers by the CMA and use listing rules. The minister provided no evidence to support the allegations. On page 28, payment of 3 billion kickback on contract from Buya Citadel Apartments. Mr. Richard Byarugaba stated that the allegations are not true. The minister provided no evidence to the committee in support of the allegations. Exchange of money for the sale of the Mbarara plot. Mr. Richard Byarugaba stated the allegations are not true. By the time the MD left the fund, the said piece of land had not yet been sold. The minister provided no evidence to support the allegation. However, it is true, the land has not been sold. Redesign of personal house of Symbion in exchange for business. Mr. Richard Byarugaba stated the allegations are not true, as the MD used the private contractors by the names of Mr. Charles Mugambe and an architect Susan Atai in 2007, way before Symbion was contracted by the fund. The minister provided no evidence to support the allegations. On page 29, commission of 5% of the contract value for Lubawa construction contracts through DePoint Consultancy Limited. Mr. Richard Byarugaba stated the allegations are not true. The minister provided no allegations to support the allegations.
No evidence.
Commission of 5%
Chair, the minister provided no evidence. Repeat that.
The minister provided no evidence to support the allegations. Commission of 5% contract value for Temangalo project from Henan Goal. Mr. Richard Byarugaba stated the allegations are not true. The minister provided no evidence to support the allegations. Observations. The committee makes the following observations. The committee noted with concern the casual manner in which the tenure of office of the MD and the Deputy MD was being handled contrary to Section 39 and 40 of the NSF Act as amended. B. The committee further noted that the tenure of office of the Managing Director and the Deputy Managing Director for reappointment is not discretionary in terms of the years to be served by the said officials under the NSF Amendment Act 2022. The recommendation by the NSSF Board for reappointment of the MD and Deputy MD for 3 years and then subsequent reappointment of Mr. Patrick Ayota as the Deputy Managing Director by the Minister for 1 year were contrary to clear provisions of Section 39 and 40 of the NSF Act as amended. The committee notes that the continued deferral of the appointment of the Managing Director, NSSF, is causing managerial gaps and thereby subjecting the Savers Fund at risk. The committee notes that Honorable Betty Ongomi, Amongi Ongom's allegations contained in her letter dated 7th December 2022 justifying the deferral of the reappointment of the Managing Director were personalized to Mr. Richard Byarugaba, and yet the same would largely apply to Mr. Patrick Ayota, the Deputy Managing Director to the fund, since all initial decisions are taken at the management committee level where both the MD and Deputy Managing Director participate for approval before they are sent to the board for approval. Petition by Mr. Richard Job Matua. During the course of the investigations, the committee received a petition from Mr. Richard Matua, who introduced himself as the petitioner against the reappointment of Mr. Richard Byarugaba as the Managing Director to the fund. Mr. Matua presented before the committee a petition with several documents to support his grounds against the reappointment of Mr. Richard Byarugaba as the Managing Director to the fund. The petitioner in his letter dated 14th December 2022 addressed the Honorable Minister of Gender requested for the following documents. A. Petitions regarding the NSF management from COF2, NOT2, NSSF staff and any other sources. B. The latest state of affairs report at NSSF. Disciplinary related correspondences between the board, Mr. Richard Byarugaba, and Minister's office. D. Documents related to the fraud embezzlement in NSSF. E. Retirement notices from the Managing Director and Deputy Managing Director. The petitioner presented to the committee all the documents highlighted above. The committee wished to know how the petitioner obtained all the NSSF internal documents presented before the committee. In response, the petitioner stated that the documents placed before the committee were furnished by the Honorable Minister of Gender, Labour and Social Development upon request in a letter dated 14th December 2022 made in conformity with the provisions of Access to Information Act. The committee noted that on 15th December 2022, a day after Mr. Job Richard Matua had requested for documents from the Honorable Minister of Gender, Labour and Social Development, responded and gave Mr. Richard Job Matua all the documents he required. Observations. The committee makes the following observations. The committee notes that the documents presented before the committee by Mr. Richard Matua were not certified by the Ministry of Gender, Labour and Social Development to show the authenticity and originality of the documents. B. The committee noted that the Honourable Minister for Labour, while appearing before the committee, reluctantly refused to give the committee petitions she had received from various petitioners when the committee requested for them to substantiate the allegations against Mr. Richard Byarugaba. She, however, gave Mr. Job Richard Matua all the documents he requested for, including the petitions, with ease and comfort. The committee notes that there is no evidence placed before it to justify any personal relationship between Mr. Richard Byarugaba and Mr. Silva Mugisha, board member of NSF, as was alleged by Mr. Matua, who claimed that they were biological brothers and that their relationship affected the day-to-day activities at NSSF.
Chair, just a minute. I want to find out from the Land Attorney General if it is true the documents were given to Matua. Was that a correct act?
Right Honorable Speaker, I need to look at the documents and look at the nature of the document and look at the internal workings of NSF to know whether they are protected documents. I can't really know at this point. But if indeed they were issued under the Access to Information Act, that is perfectly fine.
Okay.
Terms of reference number 2, 6.2, to examine the extent of stakeholder engagement at the fund. Under this term of reference, stakeholders, different stakeholder and their relationship at the fund are examined. UBRA, the annual inspections. UBRA is established under Section 2 of the Uganda Retirement Benefits Regulatory Authority Act 2011, under which the functions are stipulated to regulate and supervise pension funds, license the fund, and conduct site inspections as per Section 5 of the Act. UBRA is expected to conduct an annual review and renew the license of the board members upon satisfaction that the members meet the proper criteria. The board members at NSF have running licenses that enable them to execute their fiduciary duties as provided under Section 46 of the UBRA Act 2011 to manage and oversee the operations of the retirement benefit scheme, and also provide for the proper investment of the scheme funds, and also to appoint service providers to the scheme and to ensure that they perform their functions. Honorable members, for the interest of time, allow me to go straight to page 37. PPDA relationship with the fund's managing director. Basically, we are showing what we have skipped is how they do the fit and proper criteria tests, and the rest how they operate with NSSF. 2, PPDA relationship with the fund's management regarding procurement audits. The Public Procurement and Disposal of Public Assets Authority carries out the procurement and disposal audit of the NSSF fund on the procurement systems, procurement processes, asset disposal processes, and the procurement performance indicators in accordance with the functions stipulated under Section 7 of the Public Procurement and Disposal of Assets Act 2003 as amended, and Regulations 2014, which include a duty to advise, inspect, monitor, and report performance, approved deviation from bidding standards, among others. Honorable members, page 39. PPDA, the authority conducted periodic audit periodic audit procurements and disposal audits as indicated below. A, NSSF audit report for the financial year 2018-19 dated 15th September 2020, NSSF audit report financial year 2017-2018 dated 20th September 2018, NSSF audit report for the financial year 2016-17 dated 30th October 2017, NSSF audit report financial year 2015-16 dated 14th October 2016, NSSF audit report financial year 2014-15 dated 9th March 2016. Findings arising from the audit reports. The committee observed the following as the root causes of non-compliance in the audit that was carried out in the financial year 2016-2017. I, payment of VAT on air tickets, visa charges, and per diem to a contract. Whereas air tickets, visa charges, and per diem do not attract VAT in the procurement of an Oracle database appliance worth 611,652,751 Uganda shillings, the contractor CBL Limited charged VAT on these items. 2, irregular payment of VAT in the procurement of construction of the police guard booths for the undeveloped land in Nsimbe worth 34,556,300, whereas the contractor Mose Technical Specialist Limited was not registered for VAT. The entity paid VAT worth 5,million,271,300 against invoice number 001 dated 22nd November 2017 and invoice number 006 dated 2nd January 2018, leading to financial loss worth 5,271,300. 3, preparation of shortlists PPD at NSSF that did not promote fairness. Whereas the entity had several pre-qualified providers, few of the providers were constantly invited while others were invited outside the pre-qualification list as indicated below. In the procurement of gift sets for the regional employers meeting worth 63,897,118 shillings, only 2, Excel Brand and This and That, often invited, of the 20 pre-qualified providers were invited along 3 other unpre-qualified bidders. In the procurement of the rehabilitation of the water distribution pipe system at the workers' house, worth 408,056,803 shillings, Ugandan shillings, by Maintenance Group Limited, Challenger, Doka Investment, Wang Group, Elmark, Shine Plus, Ram Engineers, Vector Uganda, and Ball Constructions, were pre-qualified with the entity, but of the pre-qualified 9, only 1, Ram Engineers, was invited along with 7 other unpre-qualified bidders. In the procurement of CCTV cameras for Social Security House and Workers' House worth 164,848,360 shillings, 13 providers were pre-qualified, but only 2 of these were shortlisted along with 4 other providers that were not pre-qualified. The committee also observed a number of key non-compliance exceptional issues were noted, and they included the following: inadequate solicitation documents, evidenced by specification, by brand, and conflicting contractual terms issued to the bidders in 4 procurements worth 755,606,924, which could lead to failure of bidders to prepare and submit responsive bids. Inadequate technical specifications by user departments, evidenced by inadequate terms of reference, leading to low bidder participation in 2 procurements worth 1,16,429,924 shillings, which could lead to bidders failing to submit responsive bids as per the requirements. C. Execution on contracts outside the contract period, evidenced by suppliers making deliveries after contract or local purchase orders periods have expired. In 3 procurements worth 523,524 shillings, which could result in poor contract implementation and delay in service delivery. Irregularities in the evaluation of bids in the 4 procurements worth 1.3 billion, evidenced by alteration of evaluation criteria, mostly at the evaluation stage, which could result in contract award of non-compliant bidders and compromises the benefits of maximum competition. And lastly, delayed evaluation of bids in 2 procurements worth 657,902,924 shillings, which affects efficiency and service delivery. Lastly, Chief Government Valuer. The Office of the Chief Government Valuer does not have a principal legislation under which it is established. They derive their mandate from various acts of parliament granting them statutory functions, which include, among others, conducting valuation for the sale and purchase of government properties. During the committee hearings, the committee was informed that the Chief Government Valuer who testified and presented documentation as proof that his office had conducted property evaluations on behalf of NSSF. I'll go straight to C, because it has the Nachigalala land. Valuation of land comprising plot 7, Busiro block 372, Nachigalala, plot 3, Busiro block 366, Kansiri, and plots 2 and block 10 and 10, Busiro block 374, Nachigalala, Wakiso. On page 43, the Chief Government Valuer conducted valuation on the land the NSF wanted to purchase, the Nachigala land belonging to Madvani, and all the land had no encumbrances. Observation: property 1 and 3 above have the same registration instrument number 001626226, which is suspect to fraud. If you can go to 1 and 3 in the table above. This is irregular and impossible, actually. So much as the Chief Government Valuer has stated that this land had no encumbrances, we have reason to suspect fraud. When you look at the instrument number in the 3rd column, 001622626, and go to 3, 001622626, that is suspect to fraud. Honorable members, for the interest of time, allow me to go to page 46. Examine corporate governance structures at the NSSF fund. Actually, go to page 47. In Uganda, corporate governance has been defined under Regulation 3 of the Capital Markets Corporate Governance Guidelines to mean the process and structure used to direct and manage business affairs of the company towards enhancing prosperity and corporate accounting, with the ultimate objective of protecting and promoting shareholders' rights and realizing shareholders' long-term value while taking into account the interests of the stakeholders. Therefore, corporate governance can be easily understood to mean framework of policies and guidelines that inform a company's conduct, decision-making, and practice. Honorable members, Page 53. We are now looking at corporate governance in the NSSF and incidences where we believe there could be issues of corporate governance. Political undue influence and pressure in the budgeting process. Information has been adduced to the committee. Information that has been adduced to the committee indicates that political undue influence was manifested during the budgeting process. Section 29(1) of the NSF Act obligates the board in each financial year to make and submit to the minister for approval the estimates of its income, its capital recurrent and other expenditures likely to be incurred by the board for the next ensuing year. Furthermore, Section 29(2) empowers the minister to approve supplementary estimates to provide for unforeseen or urgently required expenditures on matters not provided in the estimates, or necessary additional expenditures on matters provided for in the estimates. In accordance with Section 29(3) of the NSSF Act, the minister is required upon receipt of the annual budget to approve or disapprove the budget with such amendments as she may deem necessary. From the import of Section 29, the committee observes that the role of the board is to budget while that budget is approved by the minister in undertaking their respective mandates. Corporate governance principles require the minister and the board to be independent of each other in carrying out their mandates. However, information available to the committee indicates that this is not the case, since the minister interferes in the budgeting process of the board. For instance, the former managing director, Mr. Richard Byarugaba, intimated to the committee that he was put on undue pressure by the Honorable Betty Omongi Ongom, the Minister of Gender, Labour and Social Development, to include 6 billion.
She's called Betty Amongi.
Betty Amongi Ongom. By Honorable Betty Omongi Ongom. Amongi Ongom, the Minister of Gender, Labour and Social Development, to include 6 billion in the budget for the financial year 2022-2023. During the budgeting process, we noted that when the budget was sent to the minister for approval as required in Section 29(2) of the NSF Act, the minister approved it with a rider to the chairman of the board of directors to include 6 billion for the activities stated in the budget rider by the minister, to include the following priorities. A. Undertake monitoring and oversight of the key activities of the fund, diaspora mobilization to facilitate their voluntary savings under the fund, media engagements and benchmarking for skill development. B. Development and deployment of an online application system for tracking non-compliance of employers and lodging online complaints by employees. Contributions to the fund. C. Strengthening inspection and compliance of the implementation of the NSSF Fund Act by employers in respect to the contribution through peer-to-peer enforcement and technical support to the employees on standardization of contracts for workers and incorporation of NSSF contributions. Lastly, enhancing partnerships and collaborations through stakeholder engagements. These stakeholders include, but not limited to, Parliament, Federation of Employers Association, Private Sector Foundation, and labor unions, among others. The committee further notes that the minister's letter dated 7th December 2022 addressed...
Chair, have you just said the Parliament was one of the beneficiaries of the 6 billion?
Yes. Right, Honorable Speaker and Honorable Members, the minister's justification for requesting the 6 billion was to engage Parliament, among others.
That one I can put a disclaimer: no money is coming to Parliament, nobody was going to be engaged in Parliament, no MP was going to get the money. My MPs are very clean.
The committee further notes that in the minister's letter dated 7th December 2022 addressed to the board chairman, wherein it was stated that the 6 billion was lawful, but the managing director refused to provide for it until his contract expired. In the said letter, the minister stated, and it is attached, Mr. Chairman, the law provides for activities that should be implemented by the minister. How then will the minister execute those duties if the MD is not willing to support the Ministry of Labour? Where the minister appears to suggest that she did not request for the funds for her ministry, The NSSF board, because this was contentious during our meetings, the minister kept saying she did not want this money to go to the Ministry of Gender. So we requested the board to clarify where this money was going. Wherein the minister suggests to appear she did not request for the funds for her ministry, the NSSF board in a letter dated 10th February 2023 addressed to the chairperson of the select committee confirmed that the minister requested for the funds in question for utilization by her ministry. The letter further indicates that the board did not approve the budget because the activities to back up the request were not provided. The committee further confirmed that the 6 billion was going to fund the activities of the Ministry of Labour, Gender and Social Development in the minutes of the meeting held on 14th July 2022 in the boardroom of the Ministry of Finance, Planning and Economic Development. Luckily enough, the Honourable one of the ministers who was present is here. Planning and Social Development, when it was discussed, minute 3, when Honourable Matia Kasaija, who chaired the meeting, cautioned the Minister of Gender, Labour and Social Development to desist from requesting for funding from the fund for line ministry activities. Further, in minute 5, the chairperson of NSF board requested the Minister of Finance, Planning and Economic Development to appeal to the Minister of Gender, Labour and Social Development to reconsider the proposed budget without reallocation of 6 billion since it would be hard to account for it. The Minister of Finance, Honourable Matia Kasaija, while appearing before the committee on 2nd February 2023, informed the committee that he disagreed in principle the idea of the fund giving money to the Ministry of Gender to run its activities. Furthermore, the committee received a collaborative testimony from Mr. Hassan Mudiba, a board member of NSF, who testified that while in a meeting at the Ministry of Finance, Honourable Matia Kasaija vehemently opposed the idea of Ministry of Gender receiving the funding from NSSF, thus causing a heated exchange and the meeting ending prematurely. The Minister of Finance further sought an opinion, Honourable Matia Kasaija, from UBRA, the regulatory body, which in a letter dated 5th July 2022 guided that all the monies in the fund belong to its members and should only be used for activities that are directly related to the management of funds in the interest of the savers. The committee observes that the conduct of the minister in directing the board to provide funding for activities of her ministry as indicated above, and the subsequent political pressure exerted on Mr. Richard Byarugaba when he refused to provide the said funding not only contravenes the best principles of corporate governance, but also amounts to undue influence on the decision-making process of the board by the minister. The committee notes that whereas the minister is empowered to approve the budget with or without amendment, the request of 6 billion interfered with the discretion of the board in the budget process and amounts to abuse of office by the said minister, since the ministry's activities she sought to be funded by the board or to have been funded from the funds appropriated to the ministry. The acts of the minister in this case are illegal and appear to contravene section 4.3 of the NSF Act, which obligates the board to ensure that there is secure, profitable and effective financial management of the fund for the benefit of the workers in particular and the country at large. The transfer of funds from NSF to the Ministry of Gender to undertake ministry's activities is illegal since it is not guided by law, highly risky and does not benefit the savers. It represents wastage of savers' funds, erodes the beneficial value. The activities of the Minister of Gender are financed through appropriation under the Public Finance Management Act, and therefore the minister should explain the matters for which such funding was required, which are not funded through appropriation. The minister abused her office within the meaning of the law. Abuse of office is a criminal offense under section 11(1) of the Anti-Corruption Act 2009, which provides a person who being employed in a public body or a company in which government has shares does or directs to be done an arbitrary act prejudicial to the interests of his or her employer or of any other person in abuse of the authority of his or her office, commits an offense and is liable on conviction to a term of imprisonment not exceeding 7 years or a fine not exceeding 168 currency points or both. It was held in Uganda versus Honorable Engineer Abraham Byandala and others. It was held in Uganda versus Engineer Abraham Byandala and others High Court Corruption Division, Session Case 12 of 2015, that the prosecution is required to provide the following elements against each accused on a charge of abuse of office. 1. Employment in a public body or a company in which government has shares. 2. Willfully doing or directing an arbitrary act to be done in abuse of his or authority. Lastly, which is the most important, the arbitrary act must be prejudicial to the interests of his or her employer. What is arbitrary includes such misconduct as negligence, breach of duty, unreasonable conduct, illegal conduct, and breach of rules, guidelines, and accepted practices. It was defined in Uganda versus Atgonza, Civil Suit 37 of 2010, Uganda versus Kazinda, Anti-Corruption Division, Civil Suit 139 of 2012, as an action decision or a rule not seemingly to be based on reason, system, or plan, and at times seems unfair or breaks the law. On the other hand, willful was defined in Uganda versus Hudson Jackson, Andura and Ongol Michael, High Court Anti-Corruption Division, Criminal Session Case number 0054 of 2012, as deliberately doing something which is wrong, knowing it has to be wrong, or with reckless indifference as to whether it is wrong or not. The action of the minister in directing 6 billion to be availed to her ministry amounts to abuse of office, since the minister being the supervisor of NSF without any law empowering her to do so, and knowing appropriation did an act which is prejudicial to the servers and the just administration of the NSSF. The committee also finds the actions of the minister to be arbitrary and an abuse of the duty under the NSSF Act, thereby bringing her conduct within the ambit of the prohibitions under Section 11 of the Anti-Corruption Act on abuse of office. The committee was also tongue-tied and speechless as to how the Minister of Gender Ongom came up with a budget totaling to 6 billion, which neither a work plan nor a distribution mechanism of the said money amongst the strategic activities she had proposed. So she gave the board a budget of 6 billion and activities, but no one knows how it was going to be divided amongst those activities. Undue influence during investments. Section 30 of the NSSF Act empowers the board to invest any funds of NSSF which are not required to be applied for the immediate purposes of the fund to be invested in such investments as may be determined by the board in consultation with the Minister of Finance. Section 30 of the NSSF Act grants discretion to the board to determine investments to be made. In exercise of its mandate, the board complies with the investment policy framework constituting the NSSF Act, the UBRA investment policy guidelines, and the internal investment policy of NSSF. The investment policy of NSSF provides a guiding framework for investments by the board with the overall objective of creating value for the members by generating competitive returns that provide benefits to the members in accordance with the law. The committee observes that during the investment decision-making process, the board comes under undue influence and pressure from members of the board themselves and other individuals with influence. The undue influence and pressure has led to the board to invest in projects on an ad hoc basis without complying with the investment framework, resulting into loss of the savers' funds or with little or no returns to the fund. The committee highlights that some of the instances where undue influences has been manifested, proposed investment in the Grain Council, Uganda. The minister, in her letter dated 7th December 2022, addressed the chairman of the board of directors of NSF, stated on page 8, estimated overall cost of the fund approximates 40 billion for capitalization of the program. The operational funds would initially come from the revolving lines of funding and later from retained earnings. If we can allocate 15 billion for the staff welfare and 220 billion for operations, $1 million for construction of court as corporate social responsibility, why are we dragging on the contribution of only 20 billion, which is a strategic investment proposed by a senior government official? Is there now firm commitment from the MD? I need his answer. The committee was informed that the 40 billion was earmarked for the Grain Council of Uganda project, the committee was made aware that the Grain Council project was not planned for by the board, and instead the board was solicited to invest in the project without the NSSF management conducting any feasibility studies on the project. The committee found out that the Grain Council of Uganda, to which NSSF board was resolute to invest 40 billion, was a not-for-profit organization. One wonders if due diligence was carried out by the board before deciding to invest in the project. The only information available is that they are supporting the government transformation agenda. The committee observes that the actions of the Minister of Gender, Honorable Betty Ongom, in directing the board to invest 40 billion in the Grain Council of Uganda is ultra-vires to the mandate of the Minister and the NSSF Act, since the investment decisions are a preserve of the Minister of Finance under Section 30 of the NSSF Act. Therefore, the actions of the Minister tantamount to abuse of office. The committee observes that the nature and category of investment was not clear and its subsequent benefits to the savers, and NSSF could not ascertain by the committee, thereby rendering the above decision a breach of the fiduciary duty imposed on the board under Section 4.3 of the NSSF Act. B. Land purchases by the fund. The committee notes that land is one of the avenues through which NSSF can invest. The initial investments in land, the processes and the costs show undue influence on the fund. For instances, the committee notes that the board has a detailed policy on land acquisition, but in some cases it has acted contrary to the detailed policy on the land acquisition. It has acted contrary to the policy. The investment as and when they receive unsolicited offers from vendors, commission agents, and any members of society who can approach the board or any member of the board, including board members themselves. The committee was informed of the following transactions: proposed purchase of land in Mbale and Mbuya. The committee was informed that one of the board members, Honorable Sam Lyomoki, had approached the Chief Investment Officer, Mr. Gerard Kasato, with a view of influencing the board to purchase the land located in Mbale and Mbuya, belonging to the said board member and his friend respectively. According to the letter dated 14th March 2022, authored by the Chief Investment Officer, addressed to the Chairman, Board Special Task Force Committee, the Chief Investment Officer raised a complaint against Honorable Sam Lyomoki, stating that Honorable Lyomoki had asked him for a meeting on 26 January 2022 at COF2 headquarters in Tinda. He further stated that during the meeting, Honorable Lyomoki blackmailed by alleging that the Chief Investment Officer and the MD were being paid commissions on projects. He requested that they should cooperate with him in selling the 2 pieces of land to the fund, otherwise he would not recommend them for renewal of their contracts to the board. Honorable Dr. Sam Lyomoki was the chairperson of the SACA committee, which was in charge of vetting and nominating members. The committee finds that the conduct of Honorable Lyomoki in soliciting the purchase of his land, and yet is a sitting member of the board, conflict of interest, and further gives credence to the allegations that the investment decision of the board are influenced by personal considerations to the expense of the overall objectives of the fund. As articulated in Section 4.3 of the NSF Act, the conduct of Honorable Sam Lyomoki contravenes the principle of corporate governance, especially the principle on accountability, which obligates the entities to account for and explain every action and decision taken, and are obliged to take ownership of the risks involved as means of building trust between the businesses and its stakeholders. Purchase of land, of Nachigarala land. Solicitation also manifests in the purchase of the Nachigarala land by the board, wherein in letters dated 26 February 2019 and 6 March 2019 addressed to the Managing Director of NSSF, Madvani Group offered land for acquisition by NSSF as they deemed it suitable for development into a satellite city to decongest Kampala. Following this solicitation, the MD of NSSF presented a proposal to buy the land at Nachigalala as offered by Madvani Group to the Management Investment Committee at its meeting held on 17th April 2019, which decided to carry out a detailed due diligence. The NSSF Management Investment Committee again sat on 25th September 2019 and approved 2 private valuers to conduct a legal and physical due diligence process alongside the chief government valuer. The above state of affairs begs the question as to how Madvani Group could have obtained information about the need for NSSF to build a satellite city to decongest Kampala. The committee surmises that the information could have been leaked by an insider to Madvani, who then wrote a solicitation letter to the board. The solicitation of NSSF purchase of land implies that NSSF does not have a plan for its strategic land purchases, and this explains why the fund has vast chunks of idle land in all parts of Uganda without coherent plan for their development. The reliance on vendor solicitation coupled with lack of a clear plan on land acquisition has resulted into the tie down of vast sums of money in idle land, which does not give returns to the savers. The solicitation also gives avenue for unscrupulous Ugandans a chance to defraud the fund by selling their land at values which are beyond the market value of such land, and or land over which multiple or competing interests exist, thereby subjecting the fund to protracted and costly litigation at the expense of the saved. The above examples therefore illustrate the board cannot, due to influence peddling from within and without the board, make independent, prudent, and justifiable investment decisions based on the sound economic considerations that take into account the need for savers and the current future demands of the fund. 63, nomination of representatives of employees to the and employers to the board. There were issues where by the petitioner where he claimed that some people were on the board illegally and they nominated themselves. COF2 appointments to the board. The committee learned from a letter dated 30th July 2021 to the Minister of Finance, Planning and Economic Development that Honorable Dr. Sam Nyomoki had nominated himself and Ms. Penina Kamwesiga as official representatives of COF2 to the NSSF board, and on allegations that they were COF2 executive board and SEC meetings held on 26th and 27th July respectively. During the course of carrying out investigations, the committee learned of petitions addressed to the Honorable Minister of Finance, Planning and Economic Development dated 30th August 2021 and 3rd September 2021, and subsequently to the Minister of Gender dated 15th February 2022, in which Mr. Robert Keno, the General Secretary of Uganda Scientists, Researchers and Allied Workers Union, informing the two ministers that COF2 had never appointed Honorable Sam Nyomoki and Ms. Penina Kamwesiga and requested that their appointments be revoked. The Minister of Finance, Planning and Economic Development relied on the same recommendation to appoint Honorable Sam Nyomoki. Honorable Sam Nyomoki was the Secretary General of this union. So now he is the one who writes to the Minister submitting the nomination. The Honorable Minister of Finance, Planning and Economic Development relied on the same recommendation from COF2 Secretary General to appoint Honorable Dr. Sam Nyomoki and Ms. Penina Kamwesiga to the NSSF board representing COF2 in letters dated 30th August 2021. Mr. Robert Keno, who is a SEC member, and a member of COF2, further informed the committee that the meeting Dr. Sam Nyomoki refers to above on 26th and 27th July 2021 never took place. During the select committee hearings, the Honorable Minister of Finance stated in acknowledgement of receipt of the petition he received after he had already effected the appointments of Honorable Sam Nyomoki and Ms. Penina Kamwesiga, and that the aggrieved parties were entitled to seek legal redress in the courts of law.
Chair, when you're saying the Minister of Finance and Planning and Economic Development, tell us specifically who, because we've had a number of ministers.
During the select committee hearings, the Honorable Minister of Finance, Honorable Matia Kasaij, stated in acknowledgement of receipt of the petition that he had received after he had already effected the appointments of Honorable Sam Nyomoki and Ms. Penina Kamwesiga, and that the aggrieved parties were entitled to seek legal redress in courts of law. The Treasurer General of COF2, Mr. Joseph Mbabazi, while appearing before the committee, stated that whereas the Constitution of COFTU is silent on the representation of the to the NSSF board, the same Constitution grants the powers to the Central Executive Council to determine all issues which the Constitution is silent on. He also testified
Madam Speaker, you have been emphasizing the issue of reading the report. The procedural issue I raised relates to the question you have put to the chairperson to name the minister. And the chair is naming the minister. Now, in the report here, there is no Matia Kasaija. On the floor,
what is on the report is the Minister of Finance, and I wanted him to lift the veil and know who is that minister. Who is that Minister of Finance? Because you may be looking at Musasizi when it is not him.
Yes,
so I wanted him to mention the name.
No,
he's just lifting the veil.
See the danger it has, and I think this goes to all reports. The specificity is very important.
Yes.
And
next time you need to
future,
be specific. Minister of Finance, so and so. No, it's a very good observation.
Thank you, Right Honorable Speaker. But in this particular case, there's only one minister.
Pardon?
In this particular case, there's only one minister, Right Honorable Speaker.
But in the particular case of Uganda, we have 4 ministers of finance.
Much obliged, Right Honorable Speaker.
Yes.
The Treasurer General of COFTU, Mr. Joseph Mbabazi, while appearing before the committee, stated that whereas the Constitution of COFTU is silent on the representation to the NSSF board, the same Constitution grants the power to the Central Executive Council to determine all issues which the Constitution is silent on. He also testified that there were no elections conducted by the Central Executive Council to nominate the representatives.
Honorable members, stay around to listen to the report. You all have savers in your constituencies. And I'm going to tell all the savers, if you don't see your members in the house, come back and listen to the savers report.
Upon verification, the committee established that Article 13, 6K of the Constitution of COFTU provides that the Council shall specifically carry out functions, determine any matter to which the Constitution is silent, and to make interpretation of the Constitution to the affiliates, members, and any other interested parties. The committee observes that in the case of Municipal Corporation Jabapur versus OM Prakesh Dubey, Civil Appeal number 50607 of 2006, India, court distinguished between irregular and illegal appointment, that where the appointment is in total disregard of the constitutional or legal framework, it is illegal. Where there is partial compliance with the legal framework, it is irregular. The committee further observes that the appointments of both Honorable Yomoki and Ms. Peninat Kamwesiga were illegal, void ab initio, and illegitimate, since they did not qualify to be on the board, having recommended themselves for appointment to the minister responsible for finance in disregard of the Constitution of COFTU, Article 13(6)K, wherein the Central Executive Committee, as the highest organ of COFTU, has the sole mandate to determine and interpret to all stakeholders all issues which the Constitution is silent on. This issue of selecting or nominating of a representative to the board of NSF would have been determined by the SEC of COFTU. There is no evidence that the COFTU SEC nominated Honorable Sam Lyomoki and Ms. Peninat Kamwesiga to the NSSF board as mandated by their constitution. There was also an issue as to if they were illegally nominated, does it affect all the decisions that were taken by the board during that time? In a summary, they do not, because this would be similar to Parliament. If a member of Parliament was found to be illegally, or to have come to Parliament illegally, maybe because of academic qualifications, it would not affect all the decisions Parliament could have taken during that time. Yes. The committee observes that whereas Honorable Samuel Omoki informed the committee observes that whereas Honorable Dr. Samuel Omoki...
Members, can you listen to the chair?
I'm now on page 66.
Honorable Byanyima.
Page 66, the committee observed that whereas Honorable Dr. Samuel Omoki informed the committee that the nominations of both him and Ms. Peninat Kamwesiga did take place in a SEC meeting held on 27th July 2021 by hybrid on Zoom and in a boardroom at COF2 offices in Tinda, where 31 members were purportedly in attendance, the following inconsistencies were identified. No evidence of invitation for the Zoom meeting, that is the Zoom link for the meeting, was tendered before the committee. Collaborative evidence indicates inconsistencies when the committee requested witnesses of COF2 while appearing before it to state where and when the meeting for the nomination of the members of the board was held. So when Honorable Samuel Omoki and the whole of COF2 appeared before the committee, they appeared with a large team. So we selected a few and gave them pieces of paper and isolated them. And then we asked them to each write on that piece of paper the date, the place, and who was nominated. Mrs. Beatrice Achiro stated she heard that the meeting took place at COF2 offices in Tinda, but could not remember when, since she did not attend. Did not know how many people expressed interest except for Mr. Nelson Wafana, who doesn't appear anyway, who also called and sought for her support. The information above contradicts the tendered minutes of 27th July that Honorable Omoki tendered in of the people who were in presence on Zoom, when she appears to have attended, because in those minutes she was among the people who attended, but on the piece of paper she says she was not there. Where she appears to have attended the said meeting, and similarly in the same minutes there is no mention of Mr. Nelson Wafana, who she claims to have shown interest. Ms. Grace Loyo stated that she did not know when the meeting was held and stated that only Ms. Peninat Kamwesiga and Mr. Nelson Wafana expressed interest. The information above again contradicts Ms. Grace Loyo's statement, because in the minutes of 27th July, which Dr. Samuel Omoki submitted, she was reported to have made a presentation in her capacity as Deputy Secretary General. But in this particular case, she says she did not know when and how the meeting took place. Mr. Wafana Nelson was never mentioned in the minutes as one of the persons that expressed interest in the position. The above inconsistencies creates doubts as to whether the meeting that led to the nomination of Honorable Dr. Samuel Omoki and Ms. Peninat Kamwesiga really took place. This renders the nomination of the COF2 members on SSF board irregular. Dual conflicting functions of some members on the board. During the conflicting functions of some members of the board, dual and conflicting functions of some members of the board, during interactions with stakeholders, it was found that the permanent secretary to the Ministry of Finance, Planning and Economic Development was a member of the board of both the supervising body, UBRA, and at the same time NSSF. The committee found this contrary to the best corporate governance practices, since the member was serving on a regulatory body which at the same time serving on the same entities being regulated by the regulatory body. The committee observes that one of the functions of UBRA is to, among others, approve investment policy documents which are developed by retirement schemes like NSSF. On the other hand, Section 30 of the NSSF Act grants the board powers to invest excess funds not required for immediate use. The committee notes while on the board, on one hand, the permanent secretaries of Ministry of Gender and Finance are part of the board or members of NSSF, which is regulated by UBRA. They also sit on the UBRA board as required in Section 8A and B of the UBRA Act 2011 to monitor the implementation of the UBRA Act, which Act applies to NSSF. This puts the permanent secretaries referred to above in a situation whereby they cannot freely perform their functions and mandate under both acts, since the duties imposed under those acts are in conflict with each other. This situation is called regulatory capture phenomenon, which arises in a situation where the regulator ends up doing the bidding of the very industries that have intrinsic duty to regulate. The committee is therefore concerned that the dual function of the permanent secretary is referred to above, a breeding ground for conflict of interest, abdication for their fiduciary duties, and may affect the due implementation of the UBRA Act due to their vested interest in NSSF. Relatedly, the committee found that other situations where the best corporate governance principles have not been followed, a case in point, is where the board members of NSSF are nominated or seconded to sit on controlling boards or decision-making body of an entity which NSSF has invested. The committee found that Mr. Richard Byarugaba, the then managing director of NSSF, was seconded to the board of Uganda Clays, the investee company of NSSF. We noted that Mr. Richard Byarugaba sat on the audit committee of Uganda Clays Limited at the time NSSF extended a loan of 11 billion in 2010. This loan has accrued this loan was unsecured, was an unsecured loan and has not for the past 10 years been repaid or secured. And on this particular matter, Mr. Richard Byarugaba was on the NSSF, was on the Uganda Clays Audit Committee, and Uganda Clays was not making profit for those past 2 years. So he was aware of the financial status of Uganda Clays, but however, accepted for the fund to extend a loan of 11 billion. So this is the conflict of interest we are talking about. You have to serve interests here and interests the other side. This state of affairs puts the member of the board in a conflicted situation where on one part, he has to make decisions for the good of the fund while on the same time be a member of the decision-making body of an investee of NSSF, reporting to the same board where he serves. This is a breeding ground for possible conflict of interest, influence peddling, and breach of fiduciary duty, which among others requires the duty bearer to care for, be loyal to, act in good faith, bear confidentiality, and act prudently to both NSSF board and the investee company. This is not practically possible. Supervision of affairs of the board by the minister. The NSSF Act provides for dual supervision of the board by the minister responsible for labor and the minister responsible for finance. The minister responsible for labor supervises the overall functions of the board, while the minister responsible for finance only deals with investment decisions of the board as provided in Section 30 of the NSSF Act. The committee observes that in performance of their functions, of their individual mandates, the ministers are independent of each other and usually do not consult each other. A case in point is where the minister responsible for labor, while approving the budget of the board, an additional 6 billion to be provided to the Minister of Gender to undertake certain activities related to the fund. In exercising these powers, the minister responsible for labor acted alone, and when the committee interacted with the minister responsible for finance, he indicated that he had disagreed with the minister in charge of labor on the matter of 6 billion. The committee notes the exclusive exercise of functions of each minister as provided in the Act does not guarantee the achievement of the principles of corporate governance, specifically the principle of accountability, since the other minister is prevented from questioning the excesses of the other where such excesses exist. The committee further notes instances where the supervisory functions of both the ministers overlap, the decision-making function of the board may be delayed, since in such a situation the approval of both ministers must be sought and had this, for instance, arises during the budget approval process by the minister responsible for labor, which, if the budget contains investment in a specified asset class, the investment component of the budget has to first be approved by the minister responsible for finance before the minister responsible for labor approves the entire budget of the board. In such circumstances, decision-making delays negatively affecting the fund, the achievement of its overall objectives, and is also a fertile breeding ground for conflicts between the two ministers, yet the law does not contain provisions for resolutions of such conflicts when they arise. Honorable members, on page 71, conduct of board members. The exclusive powers of the functions of each minister under the Act can further be observed in taking disciplinary action against errant board members of the board. As already noted, the overall supervisor of the board is the minister responsible for labor. The function is performed to the exclusion of the minister responsible for finance. The committee was informed of the misconduct of one of the members of the board, Honorable Dr. Sam Nyomoki, who, according to the letters from the chairman of the board of directors dated 23rd December 2022 and 10th January 2023, where the chairperson complains about the general conduct of Honorable Dr. Sam Nyomoki as a member of the board, the chairperson of board of NSF intimated to the committee that he had written several times the Minister of Gender to take action against Honorable Dr. Sam Nyomoki in accordance to Section 3.3 of the NSF Act, which empowers the minister responsible for labor to remove the member of the board on various grounds, including the misbehavior and misconduct. The committee notes that the conduct of members of the board is guided by the board charter, which among others obliges members conduct themselves in a manner that displays specific characteristics, including the integrity, accountability, informed judgment, specific characteristics including integrity and accountability, informed judgment, financial literacy, maturity, and confidence and business judgment, among others. The complaints against Honorable Dr. Sam Nyomoki were raised by the chairperson of NSF board include breach of fiduciary duty, wherein he requested for payment of 1 billion without legal justification. He's denigrating the board in public. He's threatening the chief investment officer with the view of obtaining financial inclusion. This is, he explained as cuts, commissions. Financial inclusion, influencing the board to purchase land located in Balembuya, allegedly belonging to Honorable Nyomoki and his friend respectively. He further underwent investigations by a select committee of the board. But cut the story short, on page 73, when we asked the minister why she had not taken action, the Minister of Gender, Honorable Betty Ongom, yes, even that one is her name, Honorable Betty Amongi Ongom, informed the committee that she had received several petitions against the misconduct of Honorable Nyomoki, but insisted that whereas she had the powers to remove the board members under the NSSF Act as amended, she considered it prudent not to interfere with appointments made by her colleague, the Minister of Finance, Honorable Matia Kasaija, under the old NSSF Act before amendment. Observations of the committee observes that in spite of the minister being aware of the conduct of Honorable Dr. Sam Nyomoki from various letters written to her for her action, the minister refused or neglected to bring the member to book by exercising her discretion to remove Honorable Dr. Sam Nyomoki from the office as she is empowered in Section 3.3 of the NSSF Act. The committee is concerned about the reputational damage suffered by the board arising from the conduct of Honorable Dr. Sam Nyomoki, and is of the considered opinion that the allegations should have been investigated and appropriate action taken against the member. 6.3, conflict of interest. Conflict of interest are situations in which individuals have interests that significantly threaten their roles and responsibilities, or would do so. For a typical person having their role, Michael Davis, this reference is made from Michael Davis, Andrew Stark, 2001. The committee noted various incidents where conflict of interest was manifested. During the interaction with the management of NSF, it was found that the head of business department, Mr. Geoffrey Weiss Wasaja B, was supervising various workers of blood relationship, namely A. Sarah Saja B, a sister; B. Joel Muganza, a brother-in-law; C. Amanda Acheng, a niece; D. Ian Lumonya, a nephew. The committee observes that whereas it is possible to have one's relatives in the same organization on merit, the committee observes that whereas it's possible to have one's relatives in the same organization on merit, in this particular case, paragraph 3.22 of the NSSF Human Resource Manual requires that where persons are employed in the same department, the head of department ensures that there is no direct reporting or supervisor to the subordinate relationship between the related employees. The manual further prohibits related employees from deployment within the chain of command. Where one relative may influence the other relative's work, responsibilities, salaries, career progression, benefits, or other terms and conditions of employment. Therefore, the committee finds the actions of Mr. Geoffrey Waiswa Sajabi, Head of Business Department, in contravention of Section 322 of the NSSF Human Resource Policy Manual. The deployment of those officers in the business department, which is headed by a person they share close blood relations with, is irregular and should be dealt with in accordance with the Human Resource Policy Manual. His conduct further contravenes Section 13 of the Anti-Corruption Act, which creates for offences of nepotism, which occurs where a person being a holder of an office does any act in contention with the office for the purpose of doing favors to any person on the basis of blood relations between that person and the other persons. In addition, the committee noted the case where Dr. Sam Nyomoki, a board member representing COF2 on the board of NSF, was in the same time requisitioning for funds from NSF management for COF2 activities in the capacity of the Secretary General for the following activities: enhancing awareness and training of financial literacy, B, leveraging on technology, 2, 3, mobilizing and engaging stakeholders, 4, enhancing corporate social responsibility or investment. The above is contained in a letter dated 14th December 2022 from the board member, COF2 Secretary General, addressed to the acting managing director of NSSF. In the same letter, the COF2 Secretary General goes ahead to remind the acting managing director, this is Mr. Ayota, of the 400 million budgeted and approved for the Pillar of Financial Literacy, of which 100 million had been dispersed and already utilized in Q1 of 2022-2023. For the interest of time, page 76, his prayers in that letter included: release Uganda shillings 300 million outstanding on the Pillar of Financial Literacy. 2, proposal to allocate 600 million to the financial year, for the remaining 3 years, 3 pillars, of leveraging technology, mobilizing and engaging stakeholder and corporate social responsibility and or investment. Note that the above funds were never accounted for, as accountability had never been a requirement from NSSF. One wonders how a board member of NSF would enforce accountability of any other monies dispersed by the fund in a situation where he himself is required of none. It should be noted that the amount of the funds allocated to COF2 in the same amounts. So it should be noted that the amount of funds allocated to COF2 are the same amounts allocated to NOTU. We further see COF2 Secretary General and board member recommending Mr. Ayota to staff and Corporate Affairs Committee for
Yes, Hajat.
Thank you so much, Right Honorable Speaker. Right Honorable Speaker, this report is 150 pages. He's on page 76, halfway the report. We have gotten the feel of the report. It is my humble submission and prayer that we go to the recommendations.
Honorable members, I am going to leave you with this report. You read throughout the night. You come and debate this report when you're all very sober. So the aspect of going to recommendations is okay. The aspect of going for recommendations is okay because we'll debate it tomorrow. Yes, procedure, another procedure.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I know you have ruled on the matter, but for me, this is an investigation report. This consumption is not only for us who are here. Even people out there are glued on the TVs to listen. They want to get to know what were the findings and observations. So I would really plead that let us be patient whether we reach what time. Let this information be, let the chair, and the chairman is doing very well. And the chairman is doing very well.
Chair, can you continue? Chair, continue.
Right Honorable, should I continue to the recommendations or?
You go ahead.
It should be noted, I'm still on page 76.
Honorable Guang, you people, we are in the house. Listen
should-
to the report.
It should be noted that the amount of funds allocated to COF2 are the same amounts that are allocated to NOTU. We further see COF2 Secretary General, board member, recommending Mr. Ayota to the Staff and Corporate Affairs Committee, SACA, for appointments as MD on contract, pointing to a possible syndicate. Because immediately after Mr. Honorable Dr. Sam Nyomoki recommended Honorable Ayota for reappointment, Mr. Ayota signed an MOU giving the COF2 union more money.
How much money was given to COFT Union?
Right, Honorable, these people, to avoid seeking the Attorney General's guidance on the matter, they left it blank. But when you look at their budget, it was a budget of 800 million. Million.
Okay. Yes.
Thank you, Madam Speaker. Madam Speaker, I've listened to the chair and he's making references to so many documents that have also been laid here. And I've, through the offices available in this house, asked to peruse through the documents which I laid on the table. I have found that the chair is proceeding on a report which is premised on documents that are not certified. You could request, if you choose to see if you're in agreement with me. Now the procedural issue is whether, if we are proceeding well, to entertain that report, when earlier on the chair indicated that they rejected documents submitted by one called Matua Richard because attempts they made to verify the source could not yield results and the documents were not certified. The documents laid on the table there are not certified by any authority.
Honorable,
so should we rely on them?
August Lee. Honorable August Lee. I can see how you are trying to interrupt the report. The report, the documents have just been laid on table. Your assertion is erroneous. You've not looked at the documents. Which one have you looked? Which one do you have? Can I receive the report? And that's what you'll bring in the debate. Don't divert us. Don't divert us. I don't want machineries in this house. Can you go ahead?
6.2.12 NSSF contribution to board members. Information available to the committee indicates that the members of the NSSF board have been receiving 10% contribution from NSSF.
Can I have order in the house?
Information available to the committee indicates that the members of the NSSF board have been receiving 10% contribution from the NSSF in addition to the contribution received on behalf of the members of the board from their respective representative bodies, totaling to 20% now. The committee is aware that Section 7, 1 and 2 of the NSSF Act imposes an obligation on every eligible employer to register as a member of the fund and to make regular contributions for his or her employees to the fund in accordance with the NSSF Act. Section 11(1) of the NSSF Act requires every contributing employer to pay to the fund within 15 days next following the last day of the month for which the relevant wages are paid. But for the interest of time, in examining the matter, the committee is guided by the provisions of the Employment Act and the NSSF Act. Section 3 of the NSSF Act provides that NSSF is governed by a stakeholder board of directors appointed by the minister responsible for gender and consisting of the chairperson, permanent secretary of the ministry responsible for labor, permanent secretary for the ministry responsible for finance, 4 representatives of employees nominated by the Federation of Labor Unions, 2 representatives of employers nominated by the Federation of Employers, and the managing director, who shall be an ex-officio member without a right to vote. Apart from the managing director, who is an employee of NSSF, the rest are members appointed by the minister to the board and are not employees of NSSF. Indeed, employees of NSSF are those individuals appointed by the board pursuant to Section 42 of the NSSF Act, which provides that the board may subject to such directions as the minister may give in that behalf, appoint on such terms and conditions and as it may think fit for such officers, inspectors, and employees as may be deemed necessary for the determination of the fund. In conclusion, therefore, the contribution by the NSSF for members of the board is illegal since there exists no employee-employer relationship between the members of the board and NSSF to warrant such contribution. The committee also notes that such contributions are provided as it befits a member, as it benefits a member of the board is entitled to under the board charter. Making such contributions is illegal. The total contributions will be indicated at the back. It's around 612 million that NSSF has illegally been giving board members as 10% contribution. Corporate social investment of 1.8 billion. The committee noted abuse of power, influence peddling, and circumvention of processes, information hoarding, and solicitation of investments during the budget process. We noted that when the issue of 1.8 billion corporate social investment unexplained and unitized in the budget came up, none had an explanation. The former MD, Mr. Richard Byarugaba, later shared with the committee from his phone the itemization of the 1.8 billion to include 400 million for each of the Apex unions, Notu and Koftu, 250 million for the minister responsible for labor, Honorable Betty Amongi Ongom, 250 million for the chairman of the board of directors, 500 million to be shared among the remaining members of the board. The committee was concerned as to how the 1.8 billion found itself in the budget, and yet no one could explain how it came to be included in the budget. Further probe by the committee revealed that the 1.8 billion itemized above was sent to Mr. Richard Byarugaba, phone as a WhatsApp message, because we took their phones, Mr. Richard Byarugaba and the CFO's phones, to CID Chibuli for imaging, and we verified that indeed they were sharing messages on how to allocate this money and how they had been given instructions from the board, who vehemently denied any knowledge of the 1.8 billion for corporate social investment. Mr. Stephen Mwanje's phone and Mr. Richard Byargaba's phone were handed over to CID. We processed a court order and these phones were imaged, and we shall report. When Mr. Stevens Mwanje was taken to police to make a statement regarding the above matter, he confessed having actually sent the screenshot of the breakdown of the 1.8 billion to Mr. Richard Byargaba's mobile phone. Mr. Stephen Mwanje further informed the committee that the managing director told him that he was under a lot of pressure from his bosses and thus they needed to include the figure. A section of the board members who appeared before the committee agreed to have passed the budget but vehemently denied knowledge of the purpose for the money. Mr. Hassan Mudiba, a board member, informed the committee that if we have time we can play the audios, if we don't have we can proceed.
You play it.
Play audio in the house.
I was with Silva Mujisha in Imbarara. Then Byarugaba joined us. We are standing, not even seated, after break. Then he wrote this phone. He said, "This one is for you. This one is for you." Then I said, "Under which framework?"
And what was...
now this is the one who was soliciting me. Again, he's come here telling the committee that we are putting pressure on him. And on that day, he wanted to renew his contract.
Okay. While at Mburara Hotel in Mbarara, I was with Mr. Silva Mujisha, another board member. Then Mr. Byarugaba joined us. We were standing and not even seated. He rolled his phone and said, "This one is for you, this one is for you." He was telling them now how they are going to share, according to the board member. Now, this is the one who was soliciting me, and again is coming here telling the committee that we are the ones putting pressure on him, yet on that day he wanted to renew his contract. The committee observed that whereas several witnesses kept denying having knowledge of the participated or passed the budget of the 1.8, was actually passed by the board in NSSF budget for the financial year 2022-2023 under other operating costs. Below is the extract from the budget they passed for this financial year we are in. Extract from the NSSF budget for the financial year 2022-2023, funding the strategy on the budget item, 1.8 billion is shown below. 2, several. The fund has planned joint activities with the Ministry of Gender, Labour and Social Development, Labour Unions, Federation of Uganda Employers, private sector, and members of parliament representing workers. 1.8 billion. The committee further observes that whereas the NSSF board has powers the committee further observes that whereas the NSF board has powers to
Honorable members, let the chair continue.
The committee further observes that whereas the NSSF board has powers to generate the budget under Section 39 for the approval by the minister, the same must conform to the spirit and scope of Section 4.3 of the NSSF Act, which provides for the functions of the board. The 1.8 billion allocation contravenes Section 4 in that it is not secure, not profitable, and not an effective financial management for the fund for the benefits of the workers in particular and the country at large. The diversion of 1.8 billion from its intended purpose, as indicated in the budget, to the personal aggrandizement in form of donations by board members, the Minister of Gender, Labour and Social Development, and the Chairman of the Board and the unions, Koftu and Notu, is not only a breach of the fiduciary duty imposed under Section 4.3 of the NSSF Act, but also punishable conduct under the Anti-Corruption Act, specifically the offences of embezzlement causing financial loss and abuse of office. Organizational restructuring. The committee noted that the fund was implementing a restructuring exercise. We noted that the fund hired services of Deloitte Uganda Limited, which was contracted for the provisions of consultant services for the organization redesign. The contract was signed on 17th May 2021. The fund's restructuring exercise led to the demotion and promotion of some staff. For the interest of time, page 82, which is the last term of reference. Evaluation, to evaluate the status and safety of the savers' money in the fund. Right Honourable Speaker and Honourable Members, investments of savers' money at the National Social Security Fund are guided by the fund's investment policy goal, which is to generate returns at an appropriate level of risk to provide members and beneficiaries with benefits as required by the law. The NSF statement of investment policies and goals, the committee was informed by the NSF management that the fund invests savers' money in 3 major asset classes, namely fixed income, equity, and real estate. The classes are there. A is fixed income portfolio, B is equity portfolio, C is real estate portfolio. In summary, the total fund asset performance, the total fund assets under the management fell from 17.4 trillion at the end of the third quarter 2022 to UGX 17.3 trillion at the end of the fourth quarter of 2022. Right Honourable Speaker and Honourable Members, the safety and security of savers' money at the fund is of paramount importance to their welfare and that of their immediate families, both now and in the future, and all the efforts must be taken by key stakeholders to ensure that the investment decisions taken at policy and management levels guarantee return on investments. Notwithstanding returns on investment from the aforementioned asset classes, the Select Committee noted with concern the following case scenarios where savers' money was lost. 1. Compensation of Ms. Geraldine Sally, the former Deputy Managing Director of NSF, of 1 billion as opposed to 200 million awarded by court. Honourable members, if you can allow, I can summarize these without going deep. Right, Honourable? Okay. In 2016, Ms. Geraldine Sally Busurwa, former Deputy Managing Director of NSF, filed various cases against the NSF and Mr. Patrick Byabakama Kaverenge, Those cases are there. The background of these cases is that in 2014, Ms. Geraldine Sally was reappointed Deputy Managing Director of NSSF by the Minister responsible for finance. She took maternity leave from work. On her return, was directed to go back on forced leave by Mr. Wakama Kaverenge, the chairman of the board of directors. Ms. Geraldine Sally Busura rejected the directive to go on forced leave on grounds that she did not need it because she had just returned from maternity leave. Having rejected the leave offer, the chairman of the board wrote a letter suspending her from her job, allegedly on grounds of lack of respect for her superiors. This suspension came on 14th March 2016. But in a nutshell, after her suspension, she took them to court. Court declared that the decision when Gerard Sally Busura averred the decision to say that the decision to send her on forced leave was illegal, unlawful and arbitrary and oppressive, and was outside the powers and competences of Mr. Byambakama Kabereng. However, the board members refused to reinstate her, so she went back to court seeking an injunction, which they didn't follow, and court awarded her costs of 200 million. Now, NSF appealed those costs. But now, surprisingly, 6 years after the decision, now on page 87, after NSF went and appealed not to pay her the 200 million, 6 years after the decision in the case number 116, and 5 years from the decision of the board and its meeting on 24th November 2022, resolved amicably now to settle the cases. The board could have paid 200 million, but now they have allowed, just to summarize, now to give her 1 billion plus costs of the lawyers. And this is being done in a non-disclosure agreement with the fund to give Ms. Geraldine Sally Busuru. I'm just summarizing. The committee has examined the matter surrounding the proposal to pay 1 billion to Ms. Geraldine Sally Busuru, and the committee is of the considered opinion that the proposal is not based on any legal justification. The committee is aware that the entitlement of Ms. Geraldine Sally Busuru was only 200 million, and interest accruing from the delay in the paying of the deemed sum, on the decreed sum. The other entitlement was in terms of costs arising from the various suits which court had awarded to her. Taking the award of 200 million, the interest on the sum of 6% per annum, and the delay in paying the sum by the board since the liability arose on 31st May 2016, a period of 6 years, the amount due to Ms. Geraldine Sally should be 272, including the interest, as at end of 2022, and not 752 million proposed by the board or 1 billion that was agreed by the parties. The committee is aware that the court had rejected the request of Ms. Geraldine Sally Busuru to be awarded 1 billion in general damages, and the agreement between the board and Ms. Geraldine Busuru therefore reversed the decision of court in the matter and awarded Ms. Geraldine Sally Busuru an amount that was not legally permissible, since it misapplied the determination of court. The agreement to award Ms. Geraldine Sally Busuru 1 billion is an abuse of the discretion of the board, unjustified, and contradicts the award of court in the court case number 116 of 2016. This cannot be left to stand, since it is tainted with illegality and with occasion lost to the savers. The committee is also concerned that the proposal to enter into a non-disclosure agreement between NSF and Ms. Geraldine Sally Busuru further shows that the parties knew that this agreement was illegal and sought to keep it outside the public scrutiny. By its nature, a non-disclosure agreement is intended to protect from disclosure a matter subject to the agreement. Non-disclosure agreement between NSF and Ms. Geraldine Sally is therefore contrary to the provisions of the Access to Information Act and Constitution relating to the access of information. Honourable members, for the interest of time, page 90, exit packages of resigned board members. Now allow me to summarize this. Honourable members, upon the amendment, the new amendment of the NSF Act, it created for gender balance and consideration of people with disability. However, at that time there was already an existing board. Now, the Honourable Minister of Gender, Honorable Betty Among Yongom, in the several meetings they had, agreed to dissolve, wanted to dissolve the entire board. But this could, the amendment could not work retrospective because these members were already there. Now, what they did, they had several meetings and they agreed an exit package for 2 board members to resign and get an exit package to create space for 2 ladies to come on board. I am coming to the package. Right, Honorable Speaker and Honorable Members, as some of you may recall that Parliament passed the National Social Security Fund Amendment Act 2022, among which were the powers granted to the Minister responsible for Labour under Section 3 to appoint members of the NSF board. However, we wish to draw the attention of this House that the current board, which is the 12th board, was appointed by the Minister responsible for Finance at that time under the old Act, and the appointment letters of the members are attached. On page 91, the committee was informed of an emergency consultative meeting held on 17th January 2022, convened by the Minister of Gender, Labour and Social Development, Honorable Betty Among Yongom, at Simbamayo House, in which the board members and the Attorney General and officials from KOFTU and NOTU attended. The Minister of Gender, Labour and Social Development guided that the 12th board of directors of the NSF needed to be urgently reconstituted, as it did not specifically address to gender equity concerns as provided under Articles 21, 1 and 33.4 of the Objective 6 of the National Objectives and Directive Principles of State Policy, and called for consensus on which members needed to relinquish their positions so as to ensure the gender parity of the board. During the said meetings, discussions primarily centered on the criteria to follow in guiding which constituent representatives would have to relinquish their positions to pave way for gender parity on the board. At its 5th extraordinary meeting, the Board of Directors held on Friday, 21st January 2022 at Kampala Serena, board members were advised that the only option available were to either have the current board disbanded and reconstitute a new one, or to allow the current board to continue operations on the conditions that the board members will, from amongst themselves, volunteer 2 positions to be filled with females to enable the reconstitution of the conformity with the law. During the same meeting, the board members were advised that the minister was not agreeable to the possibility of letting the current board run its full term to expiry, of which the new board would be appointed in compliance with the applicable criteria. The Honourable Minister of Gender, Labour and Social Development informed the committee that upon protracted debate without consensus, the Attorney General, Honourable Chiriwa Chiranuka, advised the minister to dissolve the board, and any consequences would be settled in court. We interacted with one of the board members, who was Mr. Bahemuka. In short, Mr. Bahemuka stated that whereas he tendered his resignation after they agreed, Mr. Bahemuka tendered his resignation, he neither did the Minister of Gender, the board chairman, nor the managing director NSF ever acknowledge receipt of this resignation. Right, Honourable Speaker and Honourable Members, at this point the board members had run out of ideas to who would relinquish the position, because the board member we met with, Mr. Bahemuka, told us it was a very juicy position. So it was hard for them to actually leave it. In a letter dated 21st January, Board Minute 1 of 2022, the board chairman, Mr. Chimbo Peter, addressed to the Minister of Gender, Labour and Social Development, Honourable Betty Yongom, communicated the following recommendations of the board in the extraordinary meeting held on the same day: that then a member required to leave the board to enable its reconstitution to be compensated with the amounts that would otherwise have been due to them for the rest of their board term, pursuant to the board appointment letters issued on 31st August. That the affected board members be compensated in cash lieu of board positions on the fund investee boards, because some of them are on different boards, so they are saying compensate them also for the other boards. Investee board, since it is not possible to guarantee board placements on the boards of the fund's investee companies. And lastly, the payments above would be made to the affected board members upon receipt of the related communication confirming their recall. In response to the board chairman, the letter, the Minister of Gender, Labour, Honourable Betty Among Yongom, indicated no objection with the principle of compensating retiring members in accordance with the fund's existing policy, legal framework, and practices. The committee was informed upon computation of the exit packages, both Mr. Fred K. Bamwesije, I think is the CEO of Uganda, of the CAA, Civil Aviation, Mr. Julius Bahemuka, were to each be compensated a gross total of 311,708,880 shillings. However, Mr. Bahemuka, while appearing before the committee on Thursday, 10th February 2023, testified, so a total of this is around 620 something. However, while appearing before the committee on Thursday, 10th February 2023, he testified that and confirmed that NSF, having credited his bank account number 1100217676 held in Housing Finance Bank Limited, Kololo branch, 175,118,964 shillings on 23rd February 2020, as opposed to the 311. The committee was informed by the financial accountant at NSF, Mr. Pius Ayebare, that crediting Mr. Bahemuka's bank account with 175 instead of 311 was due to statutory deductions such as pay and NSSF. The committee observes that the emergency consultative meeting convened by the Minister of Gender, Labour and Social Development, Honorable Betty Ongom, on 17th January 2020 Simbayo House to discuss reconstitution of the 12th board did not have clear guidelines, procedures and processes on determination of which board members needed to resign so as to reconstitute the board to take into consideration gender aspects. The committee further observes that in reaching the decision, the committee is aware that Section 3(4) of the NSSF Act empowers a member to resign from the board by giving notice of not less than 1 month in writing addressed to the minister. This same right is recognized under paragraph 5 of the board charter. The committee has examined the Act and the board charter and has found no provision entitling a resigning member of the board from being granted any benefits for exercising his or her right to resign. Resignation is voluntary and is exercised pursuant to the inherent freedom of an employee to contract. Once the members of the board decided to resign, they were free to terminate their contracts in accordance with Section 3(4) of the NSF Act. The resignation did not give them any benefits whatsoever, including compensation, because they did not suffer any wrong, which is being atoned for by compensation. The grant of compensation, now on page 96. The grant of compensation to the resigning board members of the board is therefore illegal and unjustifiable, and it represents wastage of funds by the NSF in contravention of the Section 4 of the NSF Act. Honourable members, for the interest of time, I'll go to smart cards. Projects written on, sorry. Right Honourable Speaker, honourable members, in 2010, 97. Projects written off. In 2010, the NSSF fund embarked on a number of projects, including the smart card of UGX 2.6 billion, Arua investment property. All these projects were written off. The smart card system.
There's a procedure matter.
Right Honourable Speaker, I rise on a procedure issue relating to the significance of this report and the time we have so far been seated here. We've been here, Right Honourable Speaker, for the last 4 hours. And there is now a lot of pressure on the chairperson to skip important pages to try and catch up with time. Right Honourable Speaker, the public is watching these deliberations. Each time names are mentioned, there is a lot of note-taking, both here and there, because of the consequences. Right Honourable Speaker, wouldn't it be procedurally right to have a 10 minutes break? A 10 minutes break to allow the chairperson to breathe and also to allow the members to breathe. Wouldn't it be procedurally right?
Honorable members, can we just receive a summary of the recommendations, and then we'll sleep over this report. Tomorrow we'll get an abstract, a summary of major findings in relation to the terms of reference and then the recommendations, and that is what will form our debate, so that even if you don't go and read, the chairman will still remind you tomorrow on what was discussed today. So can we just get a summary? Can we get a summary?
Right, Honorable Speaker, all the recommendations are derived from the observations, but if it's the members' wishes and under your guidance, allow me to go straight to the recommendations. We have 27 recommendations. Page 139. Honorable members and Right Honorable Speaker. Recommendations. The following agreements and memoranda executed between the NSSF and the various entities and individuals without the approval of the Attorney General as required in Article 119 of the Constitution are null and void and should immediately be terminated. A. Memorandum of Understanding. Memorandum of Understanding between NSSF and COF2. B. Memorandum of Understanding between the NSSF and Ms. Geraldine Salibusurwa, under the NSF, under which NSF agreed to pay Ms. Geraldine Salibusurwa 1 billion. 2. In order to incorporate best corporate practices in the management, the decision making, and processes of the board of NSSF, the minister should therefore appoint, before appointing representatives nominated by employers and employees, ensure that the persons nominated to the board were nominated by a body which is mandated to take such decisions in the nominating entity. B. Entities representing the NSSF board should not be contracted by the NSSF to provide services for or on behalf of NSSF in order to avert conflict of interest that arises from such allocations. C. Funds provided by the board of NSF to any persons should be accounted for within 90 days of being dispersed. 3. The committee recommends that Parliament should streamline the dual supervision of the fund. It's global practice to see pension funds as financial institutions and consequently investment vehicles and not labor institutions, as was envisaged during the amendments of the NSSF Act. We strongly recommend that NSSF Act before amendment that the NSF Act be amended, to give full supervision of the fund. With the Minister of Finance, we further recommend that the appointment of the Managing Director and Deputy Managing Director should be vested in the Minister responsible for Finance. However, the Minister responsible for Labour will remain the sole responsibility for appointing the board members for checks and balances. 4. The committee notes that the write-off of 2.3 billion invested in West Nile Golf Club is unreasonable since the board has not taken all reasonable steps to recover it and is therefore in breach of a fiduciary duty imposed on the board by Section 4.3 of the NSSF Act. The committee therefore recommends that the board should take necessary steps to protect savers' interests in the West Nile Golf Course projects, Arua, with immediate effect. The committee finds no justification for the continued holding of the land title over which Workers' House is established by Tumusime, Kabega and company advocates, and therefore recommends that NSSF takes legal action to recover the land title from Alcon and Tumusime, Kabega and company advocates with immediate effect. The committee recommends that for immediate investigations by the IGG with the possibility of prosecution, the following officers involved in conceptualization and executing the casual transaction that led to the loss of 2.3 billion, including Mr. Leonard Mpuma, the then MD, Mr. Onegi Obel, the then chairman of the board of directors, board members namely Mr. Eguya Asemo Fiona Lucy, Mr. George Baitera Maiteki, Mr. David Nkojo, Mr. Alfonso Oja Andira, Mr. Lelmoy Otong Ongaba. Other members of the board include Alozias Semanda M. Rosemary N. Senavulia, Mr. Francis Tumuhirwe, Mr. Martin Bandevide, Board Secretary Honzo Bakoru, the then minister responsible for supervision of the fund, for the possibility of offences of loss of public property, abuse of office, and causing financial loss contrary to Section 10, 11, and 20 of the Anti-Corruption Act 2009 respectively. The actions of the Minister of Gender, Labour and Social Development, Honorable Betty Amongi Ongom, in directing 6 billion to be availed to her ministry amounts to the abuse of office, since the minister being the supervisor of NSF without any law empowering her to do so, and knowing that the ministry activities are financed through appropriation, did an act which is prejudicial to the savers' funds and the just administration of the NSSF. The actions of the minister are arbitrary and an abuse of office of the duty under the NSSF Act, thereby bringing her conduct within the ambit of the prohibition under Section 11 of the Anti-Corruption Act on abuse of office. The committee therefore recommends that the Minister of Gender, Labour and Social Development, Honorable Betty Amongi Ongom, resigns in public interest with immediate effect. We further recommend that the President should take keen interest in the Minister's conduct above. Whereas the committee appreciates number 8, whereas the committee appreciates Mr. Richard Byarugaba and the entire management of NSSF for their effort in growing the fund from 1.7 trillion in 2010 to 17.3 trillion as at end of fourth quarter 2022, the committee notes their involvement in the initiation of the 1.8 billion concealed under corporate social responsibility stroke investment, 250 million for the board chairman, 250 million for the minister responsible for labor, 500 million for the board members, 800 million for the unions, where they justified before the committee that they did it because of pressure from the board members to make donations as an investment for stakeholders. The committee notes that their justification of succumbing to pressure to commit an illegality is no defense in criminal liability. The committee therefore recommends that the NSSF management that participated in the initiation of this 1.8 billion budget for donations, much as they did not participate in the final approval, Mr. Richard Byarugaba, the Deputy Managing Director, Mr. Patrick Ayota, the CFO, Mr. Stevens Mwanje, Head of Marketing and Corporate Affairs, Ms. Barbara Arimi Teddy, should step aside with immediate effect for investigations by the Office of the IGG for the offences of abuse of office, corruption, conspiracy to commit a felony with a view of immediate prosecution. The committee notes that the Chief Financial Officer, Mr. H. Stevens Mwanje, failed in his responsibility of ensuring that he obtains accountability for the monies dispersed to COF2 and NOTU amounting to 806,525,000 between January 2018 and December 2022. The committee further notes that Mr. Mwanje was employed in October 2017 in the position of CFO without being a member of the Institute of Certified Public Accountants, contrary to Section 34(2) of the Accountants Act 2013, which provides that all heads of accounts, finance, and internal audit in public and private sector entities with public interest shall be members of the Institute in accordance with the regulations made under this Act. The committee therefore notes that the employment of Mr. Stevens Mwanje as CFO at NSSF in 2017 without being a member of the Institute of the Certified Public Accountants to date was irregular, illegal, ab initio, contravening the Accountants Act 2013. The committee recommends that the board forthwith terminates his employment with NSSF. In addition, Section 35 of the Accountants Act 2013 provides for the offense of practicing without a certificate, Section 35(1) states that a person shall not practice accounts in Uganda without a certificate of practice issued under Section 28 or Section 29 of the Accountants Act. Similarly, Section 35(2) states a person who contravenes subsection 1 commits an offense and is on conviction liable to a fine not exceeding 500 currency points or imprisonment not exceeding 2 years and 10 months or both. The committee recommends that the Office of the DPP prosecutes Mr. Stevens H. Mwanje for the offense of practicing without a certificate. The committee notes that the two COF2 representatives on NSF board, Honorable Dr. Sam Lyomoki and Ms. Penina Tukamwesigwa, were illegally nominated for appointment by the Minister of Finance, Planning and Economic Development to the NSSF board. The committee recommends that the minister responsible for labor should write to COF2 to recall and legitimately nominate 2 members for appointment in accordance to their constitution. The committee notes that the actions of Geoffrey Waisa Sajabi, head of business department, for accepting the deployment of
Honorable members, let's listen. Ekanya, you've just come and you're making noise.
The committee notes that the actions of Mr. Geoffrey Waisa Sajabi, head of business department, for accepting the deployment of his relatives in the same department he heads were in contravention of Section 322 of the NSF Human Resource Policy Manual and also contravene Section 13 of the Anti-Corruption Act, which creates for the offense of nepotism, which occurs where a person being a holder of an office does any act in connection with the office for that purpose of doing favors to any person on the basis of the blood relations between that person and another person. The committee further observes that Mr. Sajabi was appointed head of business at NSF when he did not have the required qualification of a master's degree. Therefore, rendering his appointment was illegal and ab initio. The committee recommends that the NSF board terminates the employment of Mr. Geoffrey Sajabi with immediate effect. The committee further recommends the IGG investigates all departments at NSSF to establish if there are similar incidents of nepotism. 12. The committee notes that the 2 former board members, Mr. Julius Bahemuka and Mr. Fred Bamwesije, upon resignation were paid a total sum of 624 million by the NSSF board. Resignation is voluntary and is exercised pursuant of the inherent freedom of an employee to contract. Once the members of the board decided to voluntarily resign, the resignation did not give them any benefits whatsoever, including compensation, because they did not suffer any wrong, which is being atoned for by compensation. It should be noted that under the Contracts Act 2010, the compensation is only available if a party rescinds a contract under Section 63 or any other circumstances arise that lead to breach of contract. Since there is no breach of contract on the part of NSF or the minister, and the members of the board decided to resign on their own volition, they were not entitled to compensation. The grant of compensation to the resigning members of the board is therefore illegal and justifiable. It represents wastage of funds by NSSF in contravention of Section 4 of the NSSF Act. The committee therefore recommends that the board members, to wit, Dr. Peter Chimbowa, Mr. Patrick Ochailap, Mr. Agro Chivenge, Ms. Penina Tukamwesigwa, Dr. Sam Lyomoki, Mr. Julius Bahemuka, Mr. Hassan Rabai Mudiba, Mr. Fred Keba Mwesije, and Dr. Engineer Silva, who participated in the conceptualization and approval of the said payments, should collectively refund the monies to the Savers Fund within 7 working days from the date of adoption of this report. Failure to refund, they should face prosecution by the Office of the DPP for causing financial loss to the fund. The committee recommends that the Auditor General should conduct a value for money audit on the following projects: Lubo Housing Project, the NSSF Pension Towers, Yusuf Lule Land, and Temangalo Land that were undertaken by NSSF. The committee recommends that the following unions, COF2 and NOTU, should refund the 806 million they illegally received from NSSF. Specifically, Church of Violet, who withdrew 461,526,000 from account number 0100395423. Account number was withheld for security reasons of the bank. On behalf of NOTU, Honorable Dr. Sam Lyomoki, who withdrew 295 million from account number 0100462773 on behalf of COF2. The banks begged us not to disclose them. However, the statements are among the attachments. But for the interest of the report, on behalf of COF2 and A1 Joseph Mbabazi, who withdrew 50 million from the same account on 2nd September 2020 on behalf of COF2 within 7 days from the date of adoption of this report, they should refund this money within 7 days from the date of adoption of this report or first prosecution by the office of the DPP. The committee further cautions the board to desist from effecting any further disbursement to unions contrary to section 4(3) of the NSSF Act, which gives them the mandate to ensure that there is a secure, profitable and effective financial management of the fund for the benefit of the workers. 15. The committee notes that the board expenses grew by 90% and the director's expenses grew by 51% between 2021 and 2022, while research and library expenses grew by 107% between 2020 and 2021. UGX 33.3 billion bonus pay. Honorable members, you will read when you get time. The staff of NSF were given a bonus in 2 financial years. The first financial year, they gave them a bonus of 16 billion. The second financial year, they were given a bonus of 17 billion, which is totaling to this 13 billion. 33 billion, sorry. The 33 billion bonus pay to staff for the financial years 2020 and 2021 and 2021-2022, 200 million for 85 staff, 14 building in Dubai. The committee recommends that the board should be cognizant of their core responsibility, which is to ensure secure and profitable and effective financial management for the benefit of the workers while appropriating funds for operational costs in the NSSF budget, and therefore desist from such unnecessary expenditure which will occasion loss to the savers fund. The committee notes that the financial year 2022-2023, the board resolved in its meeting held on Tuesday 20th September to adopt an audit training of 4 workers representatives on the board to enhance their audit skills in Arusha, of which the budget of this session was obtained from the unallocated funds. Now, you will read, when you go to safety of savers money, there is an account in NSF called suspense account. Now, this account as of end of June last year had 57 billion. Now, if there is any way money is leaving NSSF, it's leaving NSF through this account, the suspense account. And the previous case of the NSF staff that was prosecuted, Soka, who forged IDs of people and withdrew 150 million. Now, the board is further also getting money from this account, you can see, to help, to facilitate members of the board who are going for training. And when they remove this money, they do what they call creative accounting. They can account for it because you cannot say in a financial year 27 billion on this account has been cleared. The money on this account is money of people who have not been identified. And accounts have not been reconciled. And for that to happen, these people must go to NSSF to actually open these accounts, to declare. So the committee finds this an irregular diversion of funds from the suspense account, which as at 30th June 2022 had 57 billion. The committee recommends that the Auditor General carries out a forensic audit on all transactions on the suspense account for the past 5 years and report back to Parliament within 60
Honorable
days.
members, listen.
Within 60 days from adoption of this report. We couldn't do a forensic audit, and for us to establish the names who have been withdrawing this money, it would take us almost a year. The committee notes that the NSF internal audit report for the financial year ended 2015 featured a stock of penalties amounting to 31 billion. And that arose from non-compliance in remittances of NSF contributions to the fund. You will see when you are reading, there were several companies that had penalties. When you don't remit this money, including banks, imagine a bank like Housing Finance, when you read the safety of savers money, they didn't remit this 10% contribution. So they had penalties. Housing Finance had about 1.5 billion. UCD, a government parastatal, had about 1 billion. But all this was written off by Mr. Richard Byarugaba, who wrote off all the above penalties, whereas Section 14.2 of the NSF Act gives the Managing Director the authority to do so. The committee recommends an amendment of the Act to provide for parameters within which the discretion can be exercised in waiving penalties to avoid abuse of authority for personal gain. 18, the committee notes that it was erroneous for NSF to extend an unsecured loan of 11 billion to Uganda Clays Limited in 2010 without conducting a due diligence on its creditworthiness, which accrued interest of 13.26 billion, totaling to 24.221 billion now. The committee further notes that the principal and interest was mysteriously capped at 20.592 billion in 2016, because it's supposed to continue generating interest for the SAFE. But in this case, they capped it. We don't know why. For the saver, the board is therefore putting the saver's money at risk because Uganda Clays Limited to date has only paid only 221 million of the 24.221 billion as of 2023 of the 24.221 billion and to date there is no security for the above loan. The committee recommends that the current management should take all necessary legal action with immediate effect to have the loan secured and paid. The committee notes that UBRA carried out only 3 site inspections of NSF since their establishment in 2011, with their latest being 2020, whereas the UBRA Act does not mandate them to conduct annual site inspections of NSF. As a regulator, the committee recommends UBRA carries out annual site inspections to ensure compliance. 20, the committee notes that the board members have been illegally receiving NSF contributions of 10% because there exists no employer relationship between the board members and NSF to warrant such contributions. The committee further notes that such contributions are not provided as a benefit, are not provided as a benefit of a member of the board is entitled to under the board charter, making such contributions illegal. The members who have been receiving the 10%, see the table below, by Emka Julius 37 million, Bamwesi Fred 80 million, Birunji Annette 10 million, Lemoki Sam 17 million, Mugola Isaac 43 million, Mudiba Hassan 15 million, Mujisha Silva 16 million, Mugole Stephen 32 million, Nakawunde Annette 5 million, Namata Florence Mwanje 71 million, Obita Andrew Stewart 22 million, Kamwesi Gapeni na 23 at Kamwesi Gapeni na 82 million, Wafana Nelson Makwasi 23 million, Walusi Mbisara Chibuka 39 million, Weriche Peter Christopher 37 million, Chayonka Ivan Wambuzi 11 million, Okelo Musa 13 million, Kunihira Agnes 12 million, Bijiro Richard 15 million, Mukasa Mwami 13 million, Ocheng Romano 4 million, Apira Jole Chirabo 3 million, and Kahirita Christopher 90,000, totaling to 610,770,513. The committee recommends that the above board members who have been receiving the money should refund it within 7 working days of first prosecution by the office of the DPP. The committee recommends that a lifestyle audit the committee recommends that a lifestyle audit be done by the IGG on all the officers of the compliance department because there are inconsistencies in the internal audit of companies that have been defaulting and the total contributions to NSS compared to the payee. So the people who are paying pay in some companies have more contributions and more staff than what is going to NSSF. Yet these are the same company. So we are requesting the Auditor General to do a lifestyle audit on all the officers in the compliance department. The committee notes that there are various claims of ownership of the Lubowa land NSF purchased in a letter by the former MD, Mr. Richard Byarugaba, to the then ISO Director General Kano Kaka Bajenda. He acknowledged NSSF having unauthenticated titles from Micho Courts Uganda Limited, and they were waiting for the true owner to compensate him. Yet they had already paid the other Micho Courts, and they're already undergoing investments of houses on this land. Titles, and they were waiting for the true owner to compensate him. Furthermore, the acting managing director, Mr. Patrick Ayota, informed the committee that there are actually various titles claiming the same land NSF purchased. The committee recommend, and during our interactions with these stakeholders, we received several petitions from several people who have claims of this land, and we're already investing in houses on this land. The committee recommends that NSF holds further investment on the Lubowa land and expedites the process of formalizing the true ownership of the above land. The committee recommends that the IGG should investigate with a view of prosecuting the officers, the former managing director, Mr. Richard Byarugaba, Mr. William Okabo, Mr. Daniel Batekereza, Mr. Joanita Asio, Mr. Chansemile Liko, and yes.
Did I give you some water?
And oh, sorry, it was put in the wrong way. Mr. Brian Tindimwebwa, involved in the conceptualization, procurement, and installation of the geomapping system, which caused financial loss of 748,861,114 shillings. The committee recommends the prosecution of all officers and NSF board members involved in the creation and transaction of Victoria Property Developments for causing financial loss of $2.05 million and abuse of office contrary to sections 20 and 11 of the Anti-Corruption Act 2009. This Victoria, just a brief background when you read, is very interesting. NSF carried out a joint venture to avoid litigation with PDL. It set up another company to avoid litigation called PDL. Now PDL entered a joint venture that was called Victoria Property with another company known as SBL. These were supposed to construct houses in Lubowa at $4.6 million. Now NSF further extended a loan to Victoria Property through PDL, which was 99.09 NSF and 0.01 the then MD Obel. Now the Solicitor General declared this joint venture illegal, so they cancelled the whole transaction, and $1 million disappeared from the servers in that process. Now instead it was 1 million, but because of the interest it has gone to that 2.05 million interest that should have accrued. So you read it and try to understand it in the the committee recommends that the IGG should conduct a lifestyle audit on the former managing director, Mr. Richard Byarugaba, the acting managing director, Mr. Ayota Patrick, the chief investment officer, Mr. Gerard Paul Kasato, the chief commercial officer, Mr. Geoffrey Sajabi, technology and enterprise solutions, Mr. Benon Katende, chief people and culture officer, Mr. Milton Owor, chief risk officer, Mr. Edward Senyonjo, head internal audit, Mr. Geoffrey Barige, head finance, Mr. Stephen Mwanje, head of marketing, head procurement, Mr. Gerard Mugabe, corporate affairs, Ms. Barbara Arimi, and report back to Parliament within 60 days of adoption of this report, because they are all part of management that has been approving all these projects you read that have caused financial loss. The committee recommends that NSSF should construct affordable accommodation for the savers to purchase and pay partially from their savings, as opposed to the Lubowa houses, which cost between 800 and 3 billion, and are not only too expensive but could also cause loss to the fund in circumstances where they are not occupied, as is the case now, where out of the 300 completed units, only 3 properties have partially been paid for. 27. The committee recommends that the IGG should investigate all persons who are involved in the smart card project, customer self-service touchpad, which caused financial loss of 2.6 billion and 133.283458 respectively, with a view of prosecution. The smart card, what these officers did, they developed a concept of setting up a smart card where you would go to a bank and see your balance. But this was not practically possible. They further went and they gave a contractor, an Indian contractor. They traveled to India. They were just cards that had a name and a number. But it was not practically possible to go to a bank and just access your balance without a charge. So in actual sense, the saver was going to be charged every day he was seeing his balance. But it was also not practically possible because they had not done due diligence on how it was going to operate. They further went and brought machines they put in supermarkets for you to check your balance and you get points. You call them point of sale machines. But it was not possible. Who was going to give you these points to do shopping? Under whose expense? So this, after some time, they wrote off this project, causing financial loss. Actually, after a few months. The committee recommends these include A. Ms. Sarah Walusimbi, Chairperson of the Board of Finance Committee; Ms. Agnes Kunihira, Board Member, Finance Committee; Mr. Richard Bijira, Member of Board, Finance Committee; Mr. Stevens Mwanje, Head of Sales and Operations; Mr. Collins Babiru Kamu, Head of Information Technology; Mr. Edgar Virunji, Acting Head, Marketing and Communication; Mr. Moses Modu, Customer Service Manager; Ms. Pauline Nagadia, Functional Specialist; Mr. Gerard Mugabe, Head PDU; Mr. Gerard Kalinaki, Legal Counsel; Mr. Simon Kule, Network Administrator; Mr. Daniel Batekereza, Contribution Supervisor; Ms. Geraldine Sali, who was the Deputy Managing Director of NSF at that time. In conclusion, Honorable Members and Right Honorable Speaker, the committee notes that the board has failed on several occasions, as seen in the report, to ensure that there is a secure, profitable and effective financial management of the fund for the benefit of the workers in particular and the country at large, as stipulated in the Section 4 of the NSSF Act, General Functions and Duties of the Board. The committee therefore recommends that the 12th NSSF Board be dissolved by the Minister of Gender, Labour and Social Development, Honorable Betty Amongi Ongom, with immediate effect, and a new board should be constituted. I beg to submit.
Thank you, thank you. Honorable members, honorable members, honorable members, I want to thank the chair and the members of the committee for a very, very comprehensive report, very elaborate report. It is both qualitative and quantitative, and that's what makes a report. We've had what is in the report. We are still going to read what is in the report. I want us to go. Betty, can you stop disorganizing? There is one chair in the house. Okay? You came late. You got us seated here. Keep quiet and listen. Honorable members, the issues of savers' money is a very important issue. All of you in one way or the other have savers in your constituencies. And you're here to legislate. Listen, you are here to legislate for humanity, for people outside there who cannot come and speak for themselves here. I am going to leave you to sleep with this report, sleep over it, read it. Tomorrow the chair will come and make a recap and we debate on the report. I will also ask the minister to come and make a statement on the allegations that have been brought before on her. She will make a statement on what has been said, and she will do that tomorrow. The ministers. I have a minister of gender, minister of finance. I have my members of parliament. All of them will make statements tomorrow. Pardon? The members of parliament who have been mentioned in the report.
Right Honorable, I am aware that there are some of our own colleagues who have been mentioned in this report. Maybe we would seek for your guidance. What should be the case to them? Should they make pass? Right Honorable Speaker, please, can I be heard?
Honorable Government Chief Whip.
Would they be given opportunity to make personal statements in line with
where their names are mentioned?
Exactly.
A person like Rwakajara cannot stand because his name is not mentioned. So we will want in line with what they have mentioned about them. Honorable members, and we will debate. Honorable members, we will debate this report with all the soberness, objectively, without having any bias, any business people around the house. Let's talk about the savers' money. Let's see how we save the savers' money. A wrong is a wrong. And we will not allow any machinery in this house. A wrong is a wrong. If there is something that we can do to help save us money, then we should do it. Let's do it as Parliament, 11th Parliament. You can either do it today or you will never do it. I now adjourn the House to 2 tomorrow.